Good morning. Welcome to the District of Columbia Court of Appeals. We have one case on the calendar this morning, 24 CF 665, Edwin J. Pritchett versus the United States. Counsel, when you're ready.
Thank you, Your Honor. May it please the court. I begin by addressing the matters that the court's order last week instructed us to be prepared to address. But I would like to note, if possible, that we could address here the first issue raised in the brief having to do with the trial court's intervention after the government rested and the defense had made a motion for judgment of acquittal. This court's order last week juxtaposed how both the jury verdict form only asked and the jury's verdict in open court only asked the jury to address whether Mr. Pritchett possessed a controlled substance, and then when it came to sentencing, the sentence specifically referred to cocaine as the case had been charged and tried. In addressing those matters, I do want to draw this court's attention to its decision in Fields versus United States, 952 A. 2nd 859, a 2008 decision, in which this court repeatedly said that if a case is charged as and tried as attempted possession, the government would have to prove that the defendant, what the defendant intended to possess, what controlled substance it was, specifically in that case, marijuana. And I just read a few words from the decision. In this case, the necessary element is intent to possess marijuana.
Can I ask a hypothetical about that? So, I mean, imagine that the police are focused on a particular known drug dealer who is known to traffic in both, assume for purposes of this, heroin is on one schedule and cocaine is on another schedule, and is known to traffic in both of them in powder form. And they have a surveillance operation, and they see someone go up to that person and exchange some money, and the defendant passes a Ziploc with a white-ish from a distance, not really, can't tell the hue of it, a Ziploc, and the buyer, gets off, goes off, and they try to apprehend the buyer, and the buyer swallows the Ziploc or whatever, but they can't recover the Ziploc. And they then arrest the defendant, and they find a substantial quantity of heroin and a substantial quantity of cocaine, both of them, packaged similarly, and they look pretty similar. And the government wants to charge the defendant with distribution of something. Is it your view that there's just no offense there, because there's no way a jury would be able to find beyond a reasonable doubt which of those controlled substances it was? So if you have to prove that the defendant knew that it was, one of them rather than the other, there's just no offense there. Mm-hmm. Or instead, do you think that it is, in certain circumstances at least, appropriate to to charge possession with with intent to distribute, an unknown controlled substance, or a controlled substance on Schedule 1 or 2, or something short of the exact controlled substance?
Mm-hmm. Judge, that's a hypothetical. It's not the facts of our case. So the short answer is, when the government charges cocaine and tries the case as cocaine, then yes, the jury must find cocaine.
Well, I see. So if you change the hypothetical a little bit, and are you declined to answer what you think?
Judge,
the right answer
it's a good question. It's not our case. And perhaps one answer would be that to shift from our case and our facts and what was charged and what was tried to your hypothetical would be a constructive amendment, because as you described it, we're talking about a different charge, a different trial, and even a different set of facts. So
I haven't quite followed that as a direct answer to whether you think that
Understand.
could
Now,
be
I'll
done.
give a
but
direct answer.
it-
As Your Honor said at the very end, you said maybe they can charge as Schedule 1 or Schedule 2, right? And so maybe in that situation, if the government is careful and says, Schedule 1 or Schedule 2, we still have a jury limited, and that's the way it tries it. And it's very upfront, says, listen, we didn't recover the drugs. To us, it could be Schedule 1 or Schedule 2, but it's not Schedule 3 and it's not Schedule 4. And that's the way, jury, we want you to have a verdict in this case, because as this court's questions suggest, last week, we need that sentencing judge to be aware of what you're convicting this defendant of.
So, counsel, is your problem with just the actual verdict form and what the jury said in open court when it was delivering the verdict? Or is it that, because you would agree that the only drug that was at issue anywhere in this trial at any point was cocaine, right? Other than, maybe you're referring to the medicated Mikey issue, which you can answer that way if you want. That seems kind of like a small portion of this. But is it just that the verdict form did not specify, or is it that if that's the case, then even if everyone knows that cocaine was the only drug at issue here, that we do not have an appropriate verdict for which the court to sentence beyond sort of the lowest controlled substance in the schedules?
Because we have so little evidence that the drug in question was cocaine, we don't have conversations between the go-between and the police officer who was giving that go-between cash. We don't know what they talked about. We don't have conversation with the defendant and the go-between, and we don't have a field, a scientific test of what it was.
Well, but, okay, go ahead.
So in that situation, to tell the jury, well, you don't have to find it's cocaine. You can just find it's a controlled substance. That's a constructive amendment.
What other controlled substance could the jury have thought it was? For all the jury was instructed on the law, cocaine is the only substance it's told is a controlled substance. So
Right. And the jury could have said, well, we don't need to find it's cocaine. It can be any kind of illegal substance. We think.
Well, the instruction said you have to find it's a controlled substance. And I
Right,
guess it's
any
your
kind
idea
of
that
controlled
is your idea that
Right.
no one told the jury about the existence of any other controlled substances, and that could be a technical term. But your view is are you implying that a lay juror could have thought or applied common sense and thought, there are lots of illegal drugs, and I assume that's what they mean by controlled substance. And so I don't really need to know whether it's cocaine. I could think it's some other controlled substance nobody even told me about, but that my common sense tells me exists. Is that the line of thinking?
I think that's right, Judge. I think that's the problem here. In the Cini case, on which the government relies heavily, in footnote 4, the court says, here, the defendant's acts were hardly equivocal. He approached a car that entered an area known for drug transactions and called out words indicative of offering narcotics for sale. So we don't have that kind of evidence in this case. So when you just tell the jury controlled substance, that's a constructive amendment. You're going from the specific substance that was charged, cocaine, to
You're kind of making a sufficiency argument, which you didn't make in your brief. At some point, you're suggesting that if the government doesn't put on the actual drug test results, that the evidence could be insufficient at that point. We had the government presenting testimony by, I think, 2 officers, one an expert, I think, and one maybe a fact witness. Correct me if I'm wrong, but both saying that the drug matched up with cocaine as they had seen it in their experience and training. And so your argument really is that that's not sufficient. Suppose short of the actual drug test results, the government had also put on witnesses saying, I've purchased cocaine from Mr. Pritchett, 10 times, all that sort of thing. Are you saying that's a different case?
Yeah, that is a different
So
case.
that seems to be a sufficiency argument then.
Yeah, on sufficiency argument, you know, a constructive, you're right, the brief doesn't have a sufficiency argument, but implicit in a constructive amendment challenge is that the charge on which the government was trying to prove its case to the jury, here, attempted distribution of cocaine, they didn't have enough evidence on. And so to avoid this evidentiary gap, the government has the jury charged, don't worry about controlled substance. You can render a verdict, don't worry about cocaine. You can render a verdict and you need not worry yourselves about all of our vulnerability in this case.
I just want to make sure I understand. Do you think that quid generic substance, unspecified substance is a legitimate offense?
Right, that was Judge McLeese's opening question. I think it can be troublesome, as Judge McLeese concluded with his hypothetical, saying, well, the government could say Schedule
I mean,
1 or Schedule 2.
Sorry, I think you said at the beginning of your argument, you were calling our attention to Field. And suggesting that that case decided the question, but then looking at Digsby, it seems like Digsby thinks that this question is an open one. There's the parenthetical on page 609 where the court says it's unclear whether the statute 90401A1 permits the government to charge an offense without specifying the identity of the controlled substance in question. So do you think that we need, do you know of any other case subsequent to Digsby that resolves this question? Do you think that we need to resolve this question in this case?
I don't have the sequence of Digsby. Do you happen to see the year of Digsby? I'm
Digsby
sorry.
is 2009, and I
Nine,
thought you
okay.
said Field was
Fields was
2008.
2008. Okay. I mean, Fields, to my mind, resolves this question. Yes, it says you must intent to possess marijuana is a necessary element, not my word, Fields's word. But I do think, to get back to you, to the questions that this court asked last week, the difficulty, the flaw, the problem with saying, okay, let the government choose some controlled substance, and that can be valid. The problem comes up at sentencing. When the sentencing judge has.
I mean, just to jump in, why isn't this a sentencing problem, not a constructive amendment problem, right? Seems like there's an Apprendi problem because you have this extra element that informs the punishment that never went to the jury because you only asked the jury to find that that the defendant committed attempted PWID generic substance versus attempted PWID cocaine.
I understand, Your Honor, but I was answering your broader question, which I understood to be, would it be okay for the government to charge, put the facts of our case aside, would it be okay for the government to charge some controlled substance? And I was simply pointing out one very practical problem and constitutional problem, as Your Honor noted with Apprendi, with doing that.
Well, why does it have to be a practical problem if it's done properly? Assume that it is an existent offense to charge possession with intent to distribute an unknown controlled substance. Assume for a moment that is a legitimate offense. Then one could say, well, it's punishable by, under Apprendi principles, if nothing else, it could be punished only by the provisions that are the offense that is defined by the jury's verdict. The jury's verdict would support only whatever the least stringently punished version of that offense would be, which would mean, I think, if you take Schedule 5 substances, it would be a misdemeanor. And so if you did it properly, and assuming for a moment it exists as an offense, why wouldn't it be the way you would do it is you would submit to the jury, we have no idea what this controlled substance is, but we know we can show beyond a reasonable doubt the defendant possessed it with intent to distribute it. That's all you need to find, jury. If you find it, the defendant is guilty of a misdemeanor and we sentence accordingly. What's the further difficulty other than, again, I mean, in this particular case, that wasn't done. First of all, I get that. But other than the possible non-existence of that offense, I'm not sure what I see the other problems being.
Well, it's a big problem and a possible non-existence of an offense, Judge, but.
So potential problem, it's a potential problem if adequately, briefed and objected to in the trial court. It may be less of one if those things aren't true.
Right. Your Honor, the difficulty I have is the least culpable one. So we convict someone of generic controlled substance distribution. And then that somehow, that's invalid. That's maybe not even an offense. And now we're going to say, oh, well, we'll just sentence you to the least culpable thing. No, when the government charges, as it did here, possession of cocaine with intent to distribute, when it tries the case and mentions cocaine, then that's the case it has to obtain a conviction on. And if it moves away from that to more broadly, a controlled substance, that's a
Well,
classic example of constructive amendment.
Let's just use a weapon example and see how you think that should pan out. So let's say the defendant is charged with armed robbery with a firearm, which carries with it mandatory minimum sentences that are above armed robbery with other weapons. And assume there is, and that's what the indictment says, the defendant committed an armed robbery while armed with a firearm. And then a trial, let's say there's disputed evidence, the government puts on some evidence that says it was a firearm, and the defense has some witnesses who say, well, I saw something, but I couldn't tell it was a firearm. I thought maybe it was a pipe. And the issue is whether the jury can be instructed without a constructive amendment to find armed robbery, other dangerous weapon as a kind of an included offense, because a firearm is a kind of dangerous weapon. Do you think that's a constructive amendment, or do you think that's permissible?
I'll just reread this one sentence from Fields, which said, the necessary element is intent to possess marijuana. And in your hypothetical, Judge, I think the means is what I'm getting at. It's a means of committing, was it a burglary? I think it was a burglary, a robbery, was either a firearm or some other instrument. And in that situation, that becomes not an element of the offense, but a means of achieving, doing the robbery.
Is Fields an attempt case or?
Fields is a case where, no, it was charged as a completed offense, completed, and it was post Crawford when the government had not been putting on evidence of an expert testifying as to the DEA-7. And so that was admitted in evidence as to what the drug actually was in violation of the defendant's confrontation rights. So now the government acknowledges in Fields on appeal, yes, that was reversible error. But how about sustaining his conviction for attempted possession of marijuana? And so the case becomes very useful because now, to our situation, because this court goes through the analysis of why the elements, as I just read to the court, remain the same, and under the facts of this case, without the DEA-7, even the attempted statute is the evidence is not
The whole
sufficient.
point was that attempt then places a burden on the government to prove a more specific state of mind, right? No, that the state of mind for attempt is heightened. No,
Is
heightened.
heightened. I always believe that too, but if you read the government's briefs, it says, no, in attempt, the burden is lessened, which is, that's the way I was taught in law school. It's a heightened mens rea for attempt. So this whole thing becomes, incorrect. But to stay with
Fields, can I get back to Fields for a second?
Yeah.
If Fields says, in order to prove attempted possession of marijuana, there has to be evidence the defendant intended to possess marijuana, how does that answer the question of whether A, there is an offense of attempted possession of a generic controlled substance, and B, if so, what you have to show with respect to the defendant's mens rea as to that offense? I'm not quite sure. There seems to be a leap there that I'm not following.
I understand, Judge. I hope I didn't claim that Fields answered your question about this. Does this hypothetical offense occur? Where Fields is useful is in showing that the government is incorrect in suggesting that its burden drops when it's attempted possession. In fact, the burden remains the same. The necessary element to prove intent is the same, as Judge Easterly suggested it might even be heightened. And so that's why we have a constructive amendment here, when in fact it was the same, exact same proof that should have been
Do
elicited,
you mean that?
but we drop it to a jury verdict. That's,
I get the idea that the instruction, although I don't think there was an objection to this either, I get the idea that the mens rea attempt instructions in this case relating to attempted possession of a controlled substance are confusing
Mm.
and maybe problematic. But why do they result in a constructive amendment that might mean that the judge, I mean, I guess, what is your idea that if a defendant, on the attempt piece of it, leave aside controlled substance piece of it, I guess your idea is that if the jury finds a completed offense and, I'm sorry, the grand jury returns an indictment on the completed offense and the instructions to the jury incorrectly tell the petit jury you can find the attempt offense on a lesser mens rea than the grand jury found. I see how that could be an error of law. I don't see how it could be a constructive amendment. The petit jury found the heightened element at issue. So I could see that as a instructional issue, but I don't see how it's a constructive amendment issue.
but Judge, you just said found the heightened. The argument is
The
that,
petit jury found the heightened.
yes, the petit, so.
I'm sorry.
The grand jury.
I apologize. I've
Okay.
gotten it wrong twice now. The
Okay.
grand jury found the heightened version, so they return the completed offense.
Right.
So why is it if the petit jury can find a lesser offense on lesser findings, why is that a constructive amendment?
Well, it's a constructive amendment. First, is it even a lesser offense? As your first question suggested, we don't even know if it is an offense.
I'm focused
But-
now about attempt and not so much about the controlled substance piece of it. Doing both at the same time definitely adds a lot of complexity. But
Mm.
so make it simpler. Assume that the grand jury returns an indictment for attempted possession of cocaine. And there is a question, I'm sorry, the grand jury returns an indictment for possession of cocaine. And there is a question about whether the offense was completed in some senses, and the issue is submitted to the petit jury, not only on the completed offense, but also attempted possession of cocaine. And the jury is, in your view, incorrectly told that if you are going to find attempted possession of cocaine, you can predicate that on a mens rea that is less than the completed offense. Really, it would be enough, if, something short of that. That would be an error if, by hypothesis, if that's an incorrect description of the adequate mens rea for attempt. But why is it a constructive amendment? The grand jury found intent. So it would be a mistake on this hypothesis to tell the petit jury it could do something on less, but why is it a constructive amendment?
I'm disappointed to see your brow furrowed, Judge, because to me, it's such a classic example. It's a constructive amendment is when at trial, one changes the legal theory that's gonna lead, that the jury is going to consider to convict in relation to what the grand jury has charged.
Well, not every such change. I mean, you're not saying you can't instruct lesser included offenses. I mean, if the grand jury finds assault with a dangerous weapon and there's a question at trial about whether there was actually a weapon involved, I assume you agree that the petit jury can consider simple assault and find guilt of that lesser offense on findings that were less than what the grand jury found, and that's not a constructive amendment.
Right. That's a clear lesser included example. But I don't think here what we've been talking about is lesser included. We're talking about going from cocaine, what was charged, to controlled substance.
I understand that complexity. I was just focused again on the simpler example
Right.
of if you take the drug as known and constant. So I mean, I understand some of the argument you're making I understand a little bit better when you add in the change of controlled substance. But if all it is the error in the arguable error in the instruction saying you don't have to have the same mens rea, or at least implying you don't have to have the same mens rea for attempt, by itself, I don't see that as a constructive amendment. I
Your
haven't
Honor,
gotten my head around that yet.
I understand the question, but if you read the brief, the brief doesn't just focus on the instruction. The brief talks about, as this court picked up on in its questions on the jury verdict and so forth, the broad difference between the way this case was charged and the way it was tried and the way a conviction was obtained.
So in this case, does it really matter what the exact label is? Because whether it was a constructive amendment or an instructional error, it was unpreserved, right? You would agree. And yes, a preserved constructive amendment is per se reversible error, but an unpreserved constructive amendment is, do you agree, is still subject to plain error review?
Well, this court's case law says that, and since you're asking the question, Judge, I must admit, the court's case law says constructive amendment is subject to plain error review if it's unpreserved. I've always found that body of law problematic personally, because we're talking about, okay, so the defendant was convicted of a different crime than the one he was charged with, and we're now going to take a look at whether or not that's erroneous and prejudicial. To my mind, it screams out prejudice. But in this case,
So just on that broad theory, I think, and I mean, our older cases were more reflective of the view you're just describing of finding that kind of an error as a basis for reversal relatively automatically.
right,
But then under the influence of Supreme Court cases that have had a different view,
Right.
we've adopted a different
Right,
approach. And the
right.
approach of the Supreme Court cases seems to be something like the following. And I'm just curious what you think is wrong with it. I think this paraphrasing, of course, but the gist of it seems to be the point of the grand jury right is to make sure that people aren't hailed into court on charges where there is an adequate factual basis to support them. We want to have the kind of a grand jury standing between bringing people into court on serious charges and the government's effort to do that. But if the defendant doesn't raise in trial the concern that that right hasn't been honored, and then what happens at trial is that after an otherwise fair trial, the charges that the grand jury didn't bring and really ought to have been the one to make an initial cut on are shown to have been proven beyond a reasonable doubt, then what is the fundamental unfairness that cries out for correction
right.
in the absence of a timely objection?
Right.
That's, I think, the line of thinking. And
Well,
what's wrong with that line of thinking?
My, what I interpret their line of thinking a little differently, which is that when there is overwhelming evidence of the defendant's guilt of the crime with which he was charged, then let's subject this kind of failure of to object to the amendment to plain error review, because we want to, but in cases like this one, where you have both a clear change in the nature of the charge from what was charged to what the jury verdict says, and evidence that is that, the appellate counsel can be faulted for failing to challenge its insufficiency. So you have, when you have that situation, then yes, even under plain error review, when you have no testimony, it was cocaine. When you have no scientific test, it was cocaine.
I mean, so you seem to be saying plain error standard is satisfied here, but you also seem to be implicitly then agreeing that, I mean, maybe this helps you, I don't know, but that whether we don't need to, I mean, whether we call it a constructive amendment or a jury instruction error or sentencing error of some sort doesn't really matter. Do you agree with that, or do you want us to say it was a constructive amendment?
Well, I think on the jury instruction part of your question.
If we agree with you, I'm not
Yeah,
saying
yeah,
we
no,
do,
but it's, the reason I think the constructive amendment label fits here is that, yes, it encompasses the faulty jury instruction, as Judge McLeese was saying. It also encompasses the jury verdict, which this court's questions focused in on, and it also encompasses the sentencing. So that's what that's why constructive amendment errors are so prejudicial, because they encompass those errors, a lot of errors within them, jury instructions, sentencing, and so forth. So I think the constructive amendment label is the correct one here.
You counsel, we'll let you sit down and we'll hear from the government. We'll give you a few minutes in rebuttal.
May it please the court, Dietrich Hill on behalf of the United States. like to start by saying that although there are a lot of interesting questions lurking in the background of this case, the court doesn't need to reach them because it's on plain error. And Pritchett cannot meet his burden of showing either prejudice on the third prong of the plain error requirements or manifest injustice on the fourth prong.
So just to clarify, the government's no longer pushing a waiver theory. It's just going with plain error now.
I mean, the court could find waiver as well. And I think from the way that the court has asked these questions, of course, the way that the defendant briefed it in this court constructive amendment, I think arguably waives some kind of jury instruction claim. But either way, it doesn't matter because the court can resolve it, even looking at the issues on plain error, does not have to resolve this on waiver.
Can you just clarify at the outset, are you asking us to affirm notwithstanding the questions that were posed in the supplemental or the order that we filed, the court filed a little bit ago?
No, I do want to directly address those questions because as I understand the court's concern, the question is, how do we know Pritchett was convicted of the attempted possession with intent to distribute of cocaine specifically and not some generic substance? And we know that because at every turn it was clear to everybody in the court.
Can I ask you, I would have said we know he wasn't convicted of attempted possession of cocaine with intent to distribute because the jury was told it didn't need to find that. It didn't find it. Its verdict form said it wasn't finding that. It wasn't asked to find that. And it when they announced their verdict in open court, they didn't describe their verdict that way. So I would have thought we knew he wasn't found guilty by the jury of attempted possession of a controlled substance, paren cocaine.
I have to disagree, Your Honor, but I think you put your finger on why earlier when you said, what other substance could the jury have thought it was? Because it was clear from the way that it was argued and from the evidence and from at least parts of the jury instructions that this was a charge about cocaine.
Let me just try a hypothetical on that. So imagine a case where the defendant is charged with first-degree premeditated murder. And at trial, the government abandons that charge and says, we don't intend to get a jury verdict on that. We want the case submitted to the jury on second-degree murder. The jury returns a verdict on second-degree murder. And in every sense, that's what the verdict form says. That's what they announced in open court. The instructions did not tell them to make any finding that would relate to premeditation and deliberation. And then the judge issues a judgment and commitment order that says first-degree murder, premeditated, first-degree premeditated murder. I think the United States could argue it's true that's how the case got submitted to the jury, but the facts of the case are such that, I mean, the evidence was just obvious that it was premeditation and deliberation. And, the evidence was that it was all an ID case, and whoever it was who did it, there's a ton of undisputed evidence that there was a plan and all of that. You think the United States could defend the first-degree murder conviction and sentence accordingly on the theory that although we know the jury didn't find that, and because the United States asked the jury, asked the judge to tell the jury it didn't have to find it, you could defend the judgment and commitment on the greater offense because you could tell from the jury's verdict that it must have, if asked, it would have had to the only rational answer if asked would have been that there was premeditation deliberation.
I don't think the government would defend that, but
how's that? That seems to me conceptually the same as here. So what am I missing?
No, I think it's quite different because in this case, the government did not abandon the cocaine theory and gave most of the cocaine.
Well, it depends what you mean by theory. I mean, imagine even in the hypothetical I gave, imagine during the whole trial, the government said, by the way, this is a premeditated and deliberated killing, but the United States had intentionally and consciously elected not to submit that offense to the jury. So they abandoned the offense. Put differently, if attempted possession of cocaine is an offense that is different from attempted possession of generic controlled substance, the United States abandoned the first crime and expressly asked that the jury not have to find it and prosecuted a different crime. And so how would you then defend a conviction for the crime the United States abandoned on the theory that, actually the way the case was tried, if asked, the jury obviously would have found guilt with respect to the different crime that the United States intentionally abandoned?
I just have to disagree that the government abandoned it here because there were
Abandoned the
instructions.
offense
Abandon the offense, that's
of,
right.
of attempted possession of cocaine.
Right, because there were cocaine specific instructions. Right after the 3 elements of attempted possession with intent to distribute, the court said the law makes cocaine a controlled substance. There was no mention of any other controlled substances. So the logical inference that the jury should draw in following its instructions to look only at the evidence, and the judge's instructions are.
So why did the United States ask for the instruction that the jury didn't have to find that it was cocaine? What was it doing?
And to be clear, I don't think the government asked for that instruction. I think the court offered that and neither side objected. So this wasn't some kind of intentional act by the government to lessen the mens rea here.
Maybe, but I mean, at that point, if the government's theory of the case is attempted quid cocaine, the government says, no, we want to proceed with attempted quid cocaine. If for no other reason that when they get to sentencing, they want to be able to sentence Mr. Pritchett on attempted quid cocaine, right? Not on some lesser offense. Because otherwise they've got an apprendi problem if they haven't put this before the jury,
Right.
right?
I just think that what this was an attempt to give the cocaine offense to the jury with one instruction that was, I mean, frankly, confusing. And it's a correct instruction for the completed offense, as I understand it. And so in theory, you could look.
It's not just, sorry to interrupt, but it's not just about the instruction, it's about the actual verdict that the jury returned, right? And so, you know, the jury just was told and seemingly decided not to decide that the controlled substance was cocaine. They just didn't have to go that extra step of thinking, okay, well, was he attempting to possess this particular substance? Look, he was, you know, he had money and there was this whole, you know, he's in the car and they're doing this clear hand to hand and he's working in tandem with this woman. So clearly, like, there's some contraband at issue, you know, some sort of illegal substance, but we just don't have to get, you know, to the question of whether or not this substance is cocaine. And so they didn't. I mean, they weren't instructed to, and they didn't in their verdict form.
Well, as to the verdict form and the verdict in open court, I don't think there is significance to whether or not the jury specified cocaine. The real question is, did they understand the charge to be referring to cocaine? Because if they understood the charge to be
I
referring,
don't understand that. I mean, isn't the verdict form and the announcement of the verdict in open court how we understand what it was that the jury decided, right? Are you just telling us that we don't have to pay attention to that?
I don't think there's talismanic significance to whether or not it mentions the substance, because how we know what the jury was deciding comes from the instructions.
I mean, take Judge McLeese's hypothetical, and what if the government tries someone for second-degree murder, right? And it's all about second-degree murder, and the defendant is, you know, the jury is instructed on second-degree murder, and the verdict form says, you know, second-degree murder, guilty, not guilty, and in open court they say guilty of first-degree murder.
I mean,
What
that
do
would
we do with
certainly
that,
be a
right? I
problem.
mean,
That would certainly be a problem.
that would be a problem.
But I think what happened here is more like the government seeks first-degree murder, asks for instructions on first-degree murder. There's one ambiguous instruction that makes it appear as though it could be second-degree murder, and then the jury comes back with a verdict of murder without specifying first or second degree. Now, the problem there is not the verdict itself, it's the instruction, I think.
Okay. I'm getting back to a question that I had for Mr. Cohn. Do you think PWID, generic substance, is a crime?
As
Or
I
attempt
understand,
PWID, generic
Right.
substance, is a crime?
I understand Woolley and Robinson and Digsby and Fields to have left that open, so that this court has not determined whether the generic substance.
Post apprendi, do you think it can be a crime?
I do think, and again, the court doesn't need to reach it, and as I understand it, the jurisprudence is open, but I do think the generic substance could be a crime. That would be the least included offense.
It's a practical matter, and maybe my colleagues to my right and my left can help me here too. I mean, if you charge PWID generic crime, isn't defense counsel just going to come back and say, bill of particulars, what controlled substance are you talking about? Like, why isn't that going to happen in every case? Like,
They might do that, or they might say, great, we don't want you to charge cocaine, we'll take the generic substance because that will lead to the misdemeanor conviction.
So you agree with Judge McLeese that PWID generic substance would be a misdemeanor, as would attempted PWID?
As I understand it, because that's the lowest possible for any substance would be a misdemeanor.
So here, if we had the charge of attempted PWID generic controlled substance, we have the jury verdict form that existed here and the jury's report of its verdict in open court that exists here, then we might have a problem depending on the jury instruction. And your argument seems to be that what saves your case is that the jury instruction, although it at one point said any controlled substance, it then said the law makes cocaine a controlled substance. So your case seems to turn entirely on that and the inclusion of that sentence in the jury instruction.
There are several places in the jury instructions where it's cocaine specifically. So the court says the law makes cocaine a controlled substance. In order to decide whether the material was cocaine, you may use the exhibits and expert and non-expert testimony. And then actually later in defining possession, the court says in order to determine whether the government proved beyond a reasonable doubt that Pritchett possessed cocaine, you can find either actual or constructive possession. So that all makes clear, at least I think the court and the government certainly believed that they were attempting to charge cocaine. Now, if there's, assuming that there is an
You
error.
said the court actually was the one who said, how about we just don't specify?
I think the court included that part of the instruction in error. I think if anybody had pointed it out.
But I'm just pointing. You just said, I think the court and the government thought that they were proceeding with attempted PWID cocaine, but that seems inconsistent with the court injecting attempted PWID generic substance.
I just don't think that that was intentional. I think that was essentially an error because it's in the red book as part of the completed offense, which I think is a correct statement of the law. And so in giving the attempt instruction and then the completed offense instruction, that last part of the completed offense instruction should not have been included because it applies only to the completed offense.
So leaving aside the instructions and the verdict form seems to me inconsistent with the idea that the trial judge and the government thought that the offense was attempted possession with intent to distribute cocaine, because that isn't what the verdict form said. So if the government thought that's the verdict it was trying to get from the jury, it was asleep at the wheel, as was the trial judge. Is that accurate or not accurate?
I mean, that's kind of an unfortunate way to put it, but I do think that there was an assumption on the part of the government and the court that it was clear that this referred to cocaine, and therefore they
What's the basis for your belief that that was the assumption?
Because that's the way it was argued. That was the way the evidence came in. That was the way it was argued in closing.
So closing is a good question. So is there a place in the government's closing where the government says, to be clear, we are asking you to return a verdict of guilt? There is a reference to the word cocaine once or twice, also to phrases like controlled substance. But is there a place in the government's closing, initial closing or rebuttal closing, where the government says, so, here's one of the charges. This charge is attempted possession with intent to distribute cocaine. It is an element of that you find that the defendant had the requisite mental state with respect to the particular. I mean, obviously the government didn't say the second thing that I was about to say, but it made clear one way or another that it was an element that the government was accepting as part of its proof, that the requisite mental state had to be proved with the specific drug of cocaine.
I don't think the government was that explicit at any point. I think
where was it even most implicit? Other than the word cocaine definitely appears, so I'll grant you that. But where do you think there's any indication that the government thought the offense and communicated to the jury that the offense, differently from the verdict form, was attempted possession with intent to distribute cocaine?
Well, I mean, the government just repeatedly characterizes the substance as cocaine and says that the proof was that it was consistent with cocaine. That's their proof that it's a controlled substance. In other words, the government isn't trying to prove that it is a controlled substance and it could be cocaine. They say the evidence that the defendant was attempting to distribute a substance that was very consistent with cocaine. There's no theory.
That's not a good way of proving if proving that it was cocaine was what the government was required to do beyond a reasonable doubt. Saying to the jury in closing, yeah, our evidence was it was consistent with that, is a pretty weak way of trying to communicate that thought. I mean, there are lots of things that are consistent with cocaine that may or may not be cocaine.
Right. No, but to be clear, the government didn't have the burden of proving it was actually cocaine, had the burden of showing that Pritchett was intending to possess.
Right, and where do you think the government most clearly said to the jury, by the way, we understand it's our burden to prove that he had the requisite mental state with respect to cocaine rather than a controlled substance. And we, that's the offense, that's our burden, and here's how we show it.
Right. I mean, I don't think the government was that explicit, but what it said was the evidence of this charge is that you heard that this substance was consistent with cocaine. And I mean, so we're here today because Edwin Pritchett chose to attempt to possess drugs, cocaine, with the intent to distribute them. That's from page 166. And I mean, that's probably as close as the government comes, but obviously thinking that drugs and cocaine are synonymous in this case, telling the jury that the drugs are the cocaine, right? We're not trying to show that there are drugs and they could have been cocaine. Or rather, again,
There are lots of times where you just use the word drug or controlled or the words controlled substance. So the word cocaine is certainly floated in there. And the government's theory at trial was that they had circumstantially shown that it was cocaine.
were intended to be.
Well, I think the government's theory at trial was they were circumstantially showing that it was cocaine.
Yes,
I think they probably also were thinking, I'm not sure their evidence that he was intending that it be cocaine was any stronger than their evidence that it was cocaine. I think that evidence was pretty much the same. So I'm not sure that, maybe you think there's a difference between those two, but I think the evidence supported each of them equally or to whatever number you think that equal number is. Do you disagree or you?
I think it's slightly better evidence for intended to be cocaine because theoretically a substance that experienced police officers think is cocaine, an experienced person on the street might also think is cocaine, even if they're all mistaken. So, but a very small difference. I agree. The government was attempting to show that it was cocaine as a means of showing that everybody thought it was cocaine.
Could you be more concrete about something you said? Because when I was characterizing this as a case in which the government sort of voluntarily abandoned the greater charge, if you think of it as a greater charge of attempted possession with intent to distribute, or at the time maybe possession with intent to distribute cocaine, attempted possession with intent to distribute cocaine. And you were saying the government didn't ask for the instruction that relates to you don't have to show what controlled substance is. What you said, I just want to make sure because I don't think I zeroed in on exactly what happened in the transcript of this. You're saying that was really nobody's explicit request. That was the trial court sort of taking the Red Book instruction and proposing language that's in there that relates to that. And nobody objected, but it wasn't at the request of the government.
That's my recollection.
I'm not quarreling. I just want to make sure I.
Yeah, I don't want to swear by it, but that is my recollection. And of course, that matters because if nobody objects, then it's on plain error. And so it's Pritchett's burden here to show prejudice and not the government's burden to show harmlessness.
Can I ask you, so during his argument, your opponent on the issue of prejudice acquiesced in or expressed some thinking along the following lines, part under questioning, but the idea would be kind of a common sense sort of prejudice, that it's true technically that the only controlled substance the jury heard about was cocaine. And so if you're really being rigid about it all and you're a juror sitting back there and you're told that you have to find some confusing things about the defendant's mens rea with respect to that, but let's say attempted intent, which is how maybe the two fit together somewhat confusingly, to possess controlled substance, no reasonable juror could answer that question without determining it was cocaine because that's the only, that's the only box they were given to check. Mm-hmm. I get that line of thinking, but your opponent's suggestion is that's unduly formalistic, and a lay juror is going to have common sense that there are lots of prohibited drugs, and they might even have common sense about sort of the phrase drugs or controlled substances or narcotics that are being thrown around at the trial. And they might wonder otherwise, what's the point of this instruction? Why is the jury, why is the judge giving me this confusing instruction that seems to open up the door to something that is, there's nobody there except the thing they're telling me I don't have to find.
Right.
So there's a risk that a lay juror could have responded to this by thinking, maybe this is consistent with cocaine, but nobody tested it, and nobody, and we have no direct evidence of the defendant's knowledge of any of it. I don't know what he was thinking. He's certainly acting like he's a drug dealer, if you believe the government's evidence otherwise, which the jury obviously did. But if somebody had to tell me beyond a reasonable doubt, I have to find that the defendant attempted to intend to possess this as cocaine. I'm not sure how to answer that question. Why is that a fanciful line of concern?
And can I just add a point to that? Not that it needed not that Judge McLeese needs any help, but there was a jury question specifically about why the drugs weren't tested here. So if you can add that to your answer.
Sure. I think I don't want to hang my hat just on the instruction that only cocaine is a controlled substance, because I think there were a lot of other indicators that the only question in front of the jury was this intended to be cocaine and not a generic controlled substance? So the thing right after the law makes cocaine a controlled substance is in order to decide whether the material was cocaine. The evidence that came in, the government tried to show that it was a controlled substance by showing that the substance was consistent with cocaine. That was the testimony. Nobody testified about that it could be consistent with a different controlled substance. And importantly, I know
Was there testimony that the packaging or other sorts of, I should know the answer to this, but I don't. Was there drug expert kind of testimony about packaging and the like that's consistent with drug dealing?
right, there was. And I think that
And was that zeroed in only on cocaine?
it
or
was. It was. And so, and I think that's important because you suggested, oh, the jury could have concluded, well, he's a drug dealer here. Surely he had some kind of controlled substance. But the testimony, the strongest testimony that he was, quote unquote, a drug dealer, was that this was a quantity of cocaine that was consistent with distribution and not consistent with personal use. But that isn't necessarily true of all controlled substances. So that's specific to and premised on the idea that this was or was believed to be cocaine.
Was there evidence more general that people who are selling illegal drugs tend to have weapons to protect their stashes and that they tend to have substantial quantities of cash and the like?
There was a little bit of more generic evidence, yes, to that effect, that narcotics dealers have guns. But most of the evidence, there's about 5 or 6 pages of evidence about the pricing of cocaine. Then there are a couple of pages of testimony about the quantities of cocaine, and then there's 1 or 2 pages about they also have a lot of cash. They sometimes have guns to protect themselves. But clearly, the point of this testimony was, tell us about cocaine, tell us about the quantities, tell us about the distribution of cocaine. Does this look like cocaine? And in fact, in terms of qualifying the expert and giving the background of the lay officer who testified as not an expert, in both cases, it was, how many cases have you had that involved cocaine? 1,000 cases. Or for the lay officer, it was, how often do you see cocaine or crack cocaine? Almost every day. So again, the idea is that the evidence is focused on showing that this is cocaine and not, yes, there's some evidence where you might think, okay, there's guns, there's a lot of money around controlled substances generally. But most of the evidence, and the strongest evidence that it was a controlled substance and that it was a distribution quantity, is specific to cocaine.
And most of what you've said so far about prejudice seems to be focused on the third part of the Alano test.
Yes.
Do you have anything you want to say in addition about how you think the court should approach the fourth part of the Alano test if we're getting to that stage of the process?
Right. Although I want to put a pin in that, I want to come back to the third part.
Feel free to do that first. I don't mean to interrupt you.
Okay, because I do think for the third one, basically the only way for the defendant to show prejudice here is if the jury came up with their own theory, right? That we don't buy the government's theory that this was cocaine, and we don't buy the defendant's theory that it wasn't a controlled substance. We're going to come up with our own controlled substance.
I'm sorry to interrupt. You're putting a pin in something, but you said the defense theory that it wasn't a controlled substance. If everybody was understanding that this was really a trial about cocaine, the defense closing should have been, this is not cocaine, and he didn't intend that it was cocaine. There's no proof he intended it was cocaine. And if you're not sure what it was, but you're not sure it was cocaine, you should have quit. Was that the defense closing, or was it really what you just said, which was more generic?
The defense was, there were times when they said, I think the government didn't show us cocaine, but they were more specific.
The defense specifically said, we don't know what it was.
The defense said, we don't know what it was. And then they
So
said,
that seems to support, right? Why is it that the jury had to come up with, some outlandish, defense other than doing what I was proposing earlier of just saying, they've just told us that this isn't that hard, right? Being a juror is hard, and they're asking us all these questions, and we have to make all these findings, and we're just going to find what they asked us to find. And so all they asked us to find was, do we think he had intended to possess a controlled substance? Yeah. Look at all the circumstantial evidence. Sure. Right. But why do we think that they had to take the next step of saying, oh, we think he intended to possess cocaine specifically, right?
Right. I want to go back to the first part of your question where you suggested that it was, oh, we just don't know what the drug was, because there were several times, for example, defense counsel said in order to possess with intent.
Not, we don't know what the drug was. It's just like, why do we have to think that he intended to possess cocaine? No one's asked us to do that. And we're just going to do what they asked us to do. This is a hard job. They're asking us to, convict someone, send him to prison. We're just going to do the things that we're asked to do. We're going to follow the instructions, and the instructions say, determine whether he intended to possess a controlled substance. And that's what's on the verdict form. So we're going to say, yes, that's what happened.
But the instructions also only say that cocaine is a controlled substance. Tell them that they should be deciding.
Apropos of nothing, cocaine is a controlled substance, but we're not being asked to decide whether or not he intended to possess cocaine. We're just being asked to decide, did he intend to possess a controlled substance?
Right. I mean, if you take the instructions hyper literally, the only controlled substance.
Why shouldn't we want the jury to take the instructions hyper literally?
Well, then,
right?
but then the only controlled
people.
substance
They
in
are
existence is
looking,
cocaine.
they are
So-
looking to the, no worries. They're looking to the judge to tell them, how do we walk through, how do we navigate this field of facts and get to the outcome, right? We need to have some sort of result. Like, what's the paradigm? What's the metric? Like, what decisions are we supposed to make? They get that from the instructions. We say all the time, jurors are presumed to follow the instructions. Why shouldn't we do that here? It just seems like suddenly the government is asking us to be kind of loosey-goosey about what the instructions said and what the verdict form meant. Seems kind of clear, like they were told, here's all you have to find vis-a-vis mens rea. Here's your verdict form. You're done.
I mean, the instructions, I think, were cocaine focused, although there's this one that does create some ambiguity. But I do think, to the broader question, it's possible that the jury came up with some kind of middle ground, but it's just so unlikely that they thought the government.
I mean, just again, to be super clear, not a middle ground, like just not getting to that next step. I don't see that as a middle ground. It's like, I'm just not going to take that next step of saying,
But what the government tried to show at trial is this is a controlled substance.
I get it.
Because it's cocaine.
I get it. I get it.
But
I
the
get
government
that
didn't,
was the
so-
government's theory, but I just, they never had to actually weigh in on that theory.
But can I?
And I'll let Judge Schinkert.
But if the government's theory is this is a controlled substance because it's cocaine, then it's very odd for the jury to say, well, we don't think it's cocaine, but we're going to fill in that because somehow and still come to the conclusion.
No, they don't have to fill in anything, right? Like, my daughter blows her curfew. I think that she was out with, a boy. Does it matter that she was out with a boy? I can just say she was out past her curfew. That's it, you're grounded, right? I don't have to get to the next step of thinking, what were you doing? Were you at a party? Were you out with someone that you weren't allowed to be out with, right? I just say, there was a curfew, you weren't out, you weren't home, right? It
But-
seems like it's the same thing of, well, it's some sort of controlled substance. That's it. That's all I have to decide. I don't have to get to where you were, who you were with, what you were doing. This was just wrong.
I think it's different because the only way to reach the ultimate conclusion here has to come through some substance. So it's as if instead of a curfew, there were 5 people she was not allowed to associate with. And my argument was, well, she was associating with this person. And your conclusion was, well, she definitely broke the rule against associating with these people, and who knows why. But I mean, it's a possible conclusion, but why would that be the conclusion?
But it's more possible here, right? Because I mean, this goes back to what I was asking Mr. Cohn about sufficiency. But we can't divorce this from the fact that this was a case where, we can quibble about how strong the evidence that it was cocaine is or was, but it certainly wasn't a slam dunk case that it was cocaine in the absence of testing. And then we add on to that the fact that the jury specifically asked, why wasn't this tested? So you can certainly imagine, and I know we don't try to engage in sort of speculation about what happened in the jury room, but you can certainly imagine, as Judge Easterly posited, that this is a case where the jury went back and said, okay, he was definitely dealing drugs. Okay, step two, are we supposed to find out that this was definitely cocaine? I don't know. What do you think? Well, the evidence was pretty thin on that. Let's ask the judge if it was, why it wasn't tested. Judge maybe correctly doesn't answer that question. Oh, look, we don't actually have to find out whether we don't have to find whether this was cocaine or not. We only have to find that it was a controlled substance. It seems likely or possible that that's what happened here.
But possibility is not enough, because on the third prong of a plain error prejudice, there has to be more than a possibility that this was prejudicial. And I mean, we can speculate, but as you said, we're not ordinarily supposed to speculate, or we try to minimize speculation about what happened in the jury room. So the fact that we can come up with a possible theory, if it's not a likely theory, that's not going to be enough to show prejudice, even if there was an error here.
I was going to ask you about the first issue, unless colleagues have an objection to that. So the government framed the question as to whether the court can sort of, as a general matter, reopen evidence, reopen the government's case, grant its motion to reopen its case. And then that seemed to pertain to the ultimate jury verdict, and most of the cases involved that. Was the jury verdict supported if once the government was allowed to reopen its case? But I see this more as going to the court's ruling on the motion for a judgment of acquittal based on, at the time, evidence that had not yet been admitted. It was a stipulation. Granted, it was sort of beyond dispute that it was agreed to and was going to come in, but it hadn't come in yet at the time the court ruled on the motion for a judgment of acquittal. So how could the court rule at that point before the government had actually reopened its case and had the stipulation admitted?
I don't think it was an abuse of discretion to essentially front that ruling, knowing that the evidence was already stipulated and was not going to be disputed. If the ruling, I mean, the court could have said, I deny the Rule 29 motion on everything except that I'm going to deny it the rest of the way once this stipulation comes into evidence. That might have been more technically correct, but I don't think.
Because it's a stipulation. I mean, what if it had been that the government forgot to admit a certain document during somebody's testimony? And then they said, we really want to reopen. We're going to recall this witness. We want to get them to, we want to admit this document through their testimony. Could the court then say, okay, I'm denying the MJOA at that point?
That if there's some chance it's going to be contested, then that would not be proper. If the government's going to admit some non-stipulated document, but the defense explicitly says that's fine, we are not going to object.
But if the defense takes no position at all, because they don't know how it's going to come in, what the guy's going to say, how it's going to go.
Then the court probably should wait to rule on the Rule 29 motion until it comes in.
It's dispositive for you in this case that it's a stipulation.
I don't want to concede that the court could never, or that it would always be a reversible error for the court to accidentally grant or deny the Rule 29 motion before the evidence comes in, because there might well be no prejudice if the defense is not going to contest it anyway. But surely the better course of action, if there's any chance it's going to be contested, is for the trial court to wait and rule on the Rule 29 motion after the government reopens and then rests.
I mean, it seems like formally that is, if you're looking at the language of Rule 29, I guess it depends how you analyze things, but if the government says we've rested and an issue arises and the upshot of that discussion is, well, we'd like to reopen, the government says, and the judge says, well, if you reopen and things go as you're saying they would, the evidence would be sufficient, I'm thereby ruling. I'm not quite sure the government has closed its evidence then, so I'm sure that it seems like it's a premature ruling under Rule 29A, because the government hasn't really closed its evidence. It's been permitted now to unclose what it had said was closed. So that seems like it would be a premature ruling, even if it's a stipulation. Formally speaking, it seems like it's not quite the right way to do it.
I agree. Formally speaking, yes, you should wait until the reopening.
And then, and if we move to 29B, which is about reservation of motions and what happens if a motion is reserved, 29B authorizes the judge to reserve and says you can then proceed with the trial if it's before the close of the evidence and do a whole bunch of other things. And then it has a sentence at the end that says if the court reserves, it must decide the motion on the basis of the evidence at the time the ruling was reserved. I find that a little murky in that, like in one of the hypothetical or one of the descriptions you were saying about what a judge could do. If the judge had said here, there's this motion for judgment of acquittal, I'm going to deny it as to all the counts except the felon in possession count. With respect to that, I'm reserving judgment until later when the government puts on its stipulation, and then I'll rule. That seems like it's, depending on how you interpret Rule 29B, that might be inconsistent with 29B, because 29B says that if you're reserving decision, you have to decide on the basis of the evidence at the time the ruling was reserved.
Right.
So that seems like that might be technically not quite an available option, unless you think that reservation about reserving decision only applies if the judge does more than just reserve the decision, but also then proceeds with the trial and does a bunch of other things. But that seems very murky to me. So
I agree that there's a potential ambiguity in the language of the rule, but as I read all of the cases that have permitted the government to reopen cases, they all in this court and in the federal circuits come after a Rule 29 motion. And I think the federal rule is the same in that respect. And so it's clearly just a kind of equitable or discretionary exception. If you say, I'm going to let the government reopen the case, then in fact, the Rule 29 motion, A or B, is going to be decided on the basis of everything that the government has put in until it finally rests.
I mean, if your point is you shouldn't treat all post-motion decisions to reopen as subject to the reservation rule, because otherwise then that would never be allowed, because you'd always have to have ruled it's supposed to the record at the time. So it's inconsistent with that reading of Rule 29B to say that courts have discretion post-motion to permit reopening. That I'm with you on. But there still seem the way of conceptualizing that might be that if the government originally said it was closing its evidence, and the judge, instead of ruling on a motion to judgment of acquittal, says, I'm letting the government reopen, which I guess you could think of as an implicit denial maybe, but in any event, it says I'm letting the government open, so I'm not treating the government as having closed the evidence. So I don't think I'm in this world anymore. But it does seem then that the judge should wait and rule after the evidence comes in rather than anticipatorily.
Right. Or the judge should wait and formally reserve until the end, until after the government's evidence has fully come in. I guess that's another way to frame it.
Well, no, I say, I guess if you treat a motion for judgment of acquittal as having been made and the judge saying, I'm going to let reopening and I'm reserving that my ruling on your motion right now, I'm going to reserve until after reopening. That seems that way of conceptualizing it seems inconsistent with at least one reading of the language of Rule 29B.
I agree that the language is not explicit in allowing this, but all of the cases that have allowed this, and I think there are none that have disallowed it, at least as a general matter based on the language of the rule. All of the cases say essentially you can wait and you can rule in the Rule 29 motion after you let the government reopen its case, if it's otherwise appropriate.
So is the best way to think about this then to say, if a Rule 29 motion is made and then the government asks to reopen and the court grants that motion, then the government's decision to rest, formal or informal, has been rescinded. Any MJOA is deemed premature at that point. So now we're back in the government hasn't rested territory. The government gets to put in its new evidence, and then the defense has a chance to move for a judgment of acquittal after the government presents its evidence.
I think that would be a fair way to frame it.
And then you're still subject to the court can still reserve, and Rule 29B still applies, but that works within the rules as they're currently framed.
Yes.
Okay, so that's not what happened here. Do you think there's any problem with that?
No, I think if the court may have not framed things in exactly the correct way, but the upshot here is exactly that basically now that I know the government is going to put in this evidence, I'm going to, I guess in some sense, prematurely deny the motion. But there's no effect here.
Or I'm not sure the word prematurely is needed there. I mean, the judge, nothing in Rule 29A or 29B, at least facially, seems to prohibit what I think was sort of the conceptualization you were just talking about, which is if a defendant files a motion for judgment of acquittal and the government says, oh, wait a minute, that's a mistake. There was a stipulation and we can fix that. The judge could say, I'm denying your motion. I'm not reserving, I'm denying your motion for judgment of acquittal because I am determining that I'm going to let the government reopen. And then you can, I'm denying it without prejudice to your renewal after the additional evidence is introduced in the way that people are claiming it's going to be.
Right, because the language of Rule 29 only applies to reserving. I think that's fair as well.
Well, I'm not sure I agree with that because if the court were really evaluating the motion for judgment of acquittal at that point and deciding whether to deny it or grant it, has to rule based on the evidence that is in. And in certain cases, like this particular one, by definition, two elements of the felon in possession statute have not been proven. So I don't see how the court could grant it.
Deny it.
I'm sorry. I don't see how the court could deny the motion for judgment of acquittal at that point.
Well, I mean, I think.
I know your argument ultimately is no harm, no foul in this case, but as a purely formalistic matter, I'm not sure how the court could deny it at that point.
I think as a formalistic matter, you could deny it as premature if you're allowing the government to reopen, or you could say, while the motion is pending, I'm going to allow the government to reopen, and then I'll rule on the pending motion.
Right.
Once the government reopens. If there are no further questions, we would ask the court to affirm.
Mr. Cohen, we'll give you just a few minutes.
Thank you, Judge, and I hope that some of those 3 minutes will be, to address the second point that was just discussed on the reopening and Rule 29B and so forth. I just wanted to make one point on the first issue, which is just Judge Easterly, you, to my mind, correctly focused on defense counsel's closing argument. And you focused on how the closing argument was itself focused on there's no proof of cocaine here. And my brief discusses this argument. This goes to the heart of why a constructive amendment is prejudicial, because the defense gears itself to a certain defense. Here, there was no proof of cocaine. And then, poof, the case gets changed. The jury verdict doesn't even ask about cocaine. That's the prejudice. That's the constructive amendment. That goes to the heart of our case. On issue one, going to the heart of our case, where my adversary is correct is that this court has given discretion to judges in these Rule 29 reopening situations to grant a government motion to reopen the evidence. But that is not what happened here. Here, it was the trial judge himself who said, I've heard your Rule 29, and this is in our brief, but the government didn't put in evidence as to two of the essential elements of the offense.
Can I actually just stop right there? Are you saying that was itself wrong? That a trial judge, if an offense has 4 elements and a defense attorney in, let's say at the close of the government's case, orally makes a motion for judgment of acquittal and says 2 things, element 1, not enough, element 2, not enough, and just says nothing about elements 3 and elements 4. Are you saying there should be a flat rule? The judge has no function in saying nobody's focused on element 3, but I have some concerns there too. That's just out of bounds right then? Or do you think that the judge went off the rails some later point and that right there was okay?
I think that's where the judge went off the rails. And I will now read a sentence that I find very troublesome from the government's brief. Pritchett ignores that the trial court, had a duty to ensure that each element of the charged offenses was proved. Page 14 of the government's brief. That can't be the law. as Chief Justice Roberts famously testified in his confirmation hearings, the work of a judge is to call the balls and strikes, not
I
to
get-
ensure that one
I
party.
get that abstract line of thinking, but more concretely, are you aware of any authority that suggests that a trial judge, because again, initially, a trial judge's intervention there could be, I mean, it might have no interest in advancing anybody's party, in the interest of any party. It's just like, I have a question here. I'm trying to figure something out. Do you have any support for the idea that it's impermissible for a judge to ask a question about the status of the evidence on what hadn't been at that point specifically contested element of sufficiency?
On that one, Judge, I would rely, as you did earlier, on Rule 29B, which
Can
to
I ask
my
you another
mind-
question too, which is, it seems like we have special issue preservation rules about the sufficiency of the evidence, so that unlike a lot of things, the sufficiency of the evidence on appeal can be raised, specific arguments can be raised about the sufficiency of evidence on appeal that were not directed to the trial court. That's particularly true in bench trials, but it's true to a degree in jury trials as well. So one could say that even if a defense attorney generally submits on the evidence, the Court of Appeals is going to be reviewing about whether there was sufficient evidence to support the conviction on all of the elements. And the fact that the defense attorney hasn't zeroed in on that doesn't relieve the trial court of the obligation to answer that question, one could say. Now, it's a little trickier if the defense attorney has identified some and not other considerations, or cases are somewhat confused on that, or over time, or somewhat inconsistent on it. But it seems a tough interaction between this idea that the Court of Appeals is going to review the sufficiency of the evidence without regard necessarily to very specific arguments that were made by the defense attorney, and more generally about, was there sufficient proof to submit this to a jury? If that's true, then it does seem like the judge might have a kind of a Court of Appeals imposed responsibility to actually answer that question, not zeroed in solely on the specific points the defense attorney is making, but also with respect to all of the elements of an offense. Do you have a reaction to any of that?
I disagree.
More concretely.
I don't. First, there are a couple of things that are going on, Judge, respectfully, that in your question, first, you're substituting the responsibility of defense counsel to object for the responsibility of the government to put on its proof before it rests. Second, you're taking the appellate standard for sufficiency and shifting it over down to the trial court level. And beyond that, I do think that, as you were suggesting, Rule 29B, when it says that the judge can reserve decision, but the evidence, once the decision is made, must be based on what it was at the time of the motion for judgment of acquittal, implicitly prohibits what happened here for the judge to say, I think you forgot about two elements here, so why don't you go ahead and do that? To my mind,
But what if
The court
the,
said no words like those. The trial court said no words like those, right?
well, let's see what the trial court
What-
said.
Yes, I'm just, while you're looking for that, I'm wondering what you do with the sentence in Rule 29A that says the court may on its own consider whether the evidence is insufficient to sustain a conviction.
Right.
What does that sentence mean?
I think it means it can grant a judgment of acquittal if it finds the evidence insufficient.
right, but
I don't think
that's what the court, I mean, when the court asks the question, so defense counsel in the trial court said, we think the evidence was insufficient on elements 1 and 2. Suppose the court had said, I disagree with you on that, on elements 1 and 2, but I actually wonder whether the evidence was insufficient on elements 3 and 4. Isn't that what the defendant wants the trial court to do, and that the language that Judge Easterly just quoted indicates that the trial court is supposed to do at that point? And so then the court would ask the government, what was your evidence on 3 and 4? And we know, practically speaking, this is oral, right? We don't have transcripts yet, generally speaking, at this point. Trial court is actually honestly trying to remind itself of what the evidence was on elements 3 and 4. So that can't really be where your beef is, that it does come down to what the trial court did after that. That has to be where your complaint is, right?
I think so. I also want
But
to
you
mention.
seemed, but you
um,
seem to be saying that the trial court couldn't even ask the question. And that's where we're having a little trouble, I think.
It's important as we discuss this to bear in mind the chilling effect on defense motions for judgment of acquittal. If a defendant, when the lawyer makes a motion for judgment of acquittal, is realizing, there's a risk here that in my pointing out correctly the failure of proof, well, what's going to happen is I'm going to have two adversaries in the courtroom because my trial judge is now going to say, you may be right, counsel. Mr. Prosecutor, do you think you ought to reopen your case to discuss?
But no, you're,
What I mean, I grant you, like, if the trial court is up there after an MJOA is made and turns to the government and says, fix this, that could be problematic. That's not what happened here. The court said, okay, I hear you that you think possession has not been proved. And in addition to what the defense has argued, I'm going to have the government tell me what evidence, if any, the government presented on the elements 3 and 4 of the possession of the firearm, right? So the court is just inviting the government to, respond. And why doesn't the defense want the court to do that? And why, again, doesn't Rule 29A authorize the court to do that? I mean, it seems like that decision as a policy matter has already been made, that we want courts to vet the evidence so that unnecessary charges don't go to juries. They are just not supported by the evidence. And the court notices that beforehand, whether or not defense counsel notices it. We can clear the decks, get rid of some charges that just aren't proved before we send
Right.
charge.
That's not what happened here. The judge was saying,
But why wasn't the court's inquiry to that end, right? As it happened, then the government said, oh my gosh, we forgot this stipulation, may we move to reopen? And that's what Judge Schenker was pointing to, saying, well, is that your problem, that the court abused its discretion in reopening? But the court's question of the government of what evidence did you present to substantiate this element of the offense, that seems not only not problematic, it seems authorized under Rule 29.
disagree. We disagree. And the trial defense counsel also disagreed because he promptly objected after this happened. He said, Judge, I deliberately did not go into what was the obvious failure to introduce in evidence the stipulation in my judgment for motion of acquittal. I thought we were done. I thought the government arrested. I object to reopen.
that seems weird. It seems more natural defense counsel would have said, there was no evidence on 1 and 2 and definitely no evidence on 3 and 4 because nothing came in about 3 and 4. End of story. You have to grant my motion for a judgment of acquittal, at least on this count, right? If your characterization of what defense counsel was doing is right, that would have had to have been what he should have done, right?
Yes and no, Judge. I think the trial counsel could have sensed that he had a particular trial judge. And I think the defense counsel makes a motion for judgment of acquittal and has a justifiable expectation that the case is rested. And if the government's going to reopen, it's not going to be because the trial judge has told him, hey, you guys need to reopen your case. That's not the way the rules are designed. And Judge Easterly, I just want to be clear. If I understood your question correctly, you were talking about a situation where the evidence could not go to the jury because the evidence was insufficient at the Rule 29 stage. And therefore, the judge has the power under 29A to, regardless of defense arguments, to say, I don't think there's sufficient evidence. I'm not letting counts 1 and 2 say, go to the jury. But as I understand, that's the opposite of what happened here. The judge said, I think there's sufficient evidence. We just haven't heard it yet.
The court didn't say, I think there's sufficient evidence. The court said to the government, I want you to address what evidence is there to these elements.
Right.
And it just seems perfectly, I mean, it seems clearly authorized under Rule 29A for the court on its own to consider whether evidence is insufficient to sustain a conviction. And those questions were to that end. That's why the court was asking. Now, what the court does after the government responds to its questions, that seems to be where your real problem is. The court then allowed the government to reopen. And your point is, well, the defense thought the government had rested and they were going to try and, take the strategic advantage. They, seemingly didn't say anything about this on purpose. I'm not sure that the record really reflects that, or whether they were just taking advantage of the court recognizing that this element hadn't been presented, but be that as it may, the defense, your objection seems to be the court shouldn't have allowed the government to reopen. They made their bed, they rested, and they, it should have been done. That's a different argument. I don't see, critiquing the government for asking the question. It just doesn't seem to get you very far.
Digging the judge for asking the question.
For asking about the sufficiency of the evidence,
Right.
for asking the government, what is your evidence as to this element? That seems to be the kind of question that we want judges to ask. And it seems to be the kind of question that Rule 29 contemplates.
Judge, I disagree. I think Rule 29 is not meant to authorize a judge to say, government, it seems that you haven't proven your case. And would you like to reopen? I don't,
The court
that's not my
never
reading.
asked the judge, never asked the government if it wanted to reopen. Right? Why wouldn't you want the court to just make sure, right? Wait a second, as Judge Schenker said, the court doesn't have a transcript at this point. It's probably taken notes, but just to be sure, wait a second, what was the evidence that you put in on this? Instead of shooting from the hip and saying, I think the evidence was or was not sufficient.
Judge, I would distinguish that situation. If the trial judge truly has doubts about what the record was, pause the case, go back in chambers, look at the transcript and make a ruling. But
The
if
court should not speak to the parties at all about the sufficiency of the evidence one way or another. If it's gonna exercise its authority under this sentence under Rule 29, it should keep its thoughts to itself. Don't ask anything of the
yeah,
defense.
the
Don't
pending
ask
motion
anything
is
of
a
the
motion for judgment of acquittal. It looks at the evidence at that point and rules.
All right. Thank you, counsel.
Thank you, Judge. Thank you.
Appreciate your arguments. Thank you to the government. Case will be submitted.